schedule of the symposium. Yeah? So I'm going to start. So good afternoon, distinguished guests, distinguished speakers, colleagues, friends from around the world. On behalf of the CyJurII Students International Initiative, it is my great pleasure to welcome you to the third and final day of our first anniversary celebration. Over the past year, the initiative has grown to a truly international platform dedicated to advancing dialogue and research at the intersection of law, technology, cybersecurity, and artificial intelligence. During these 3 days, we have explored pressing legal questions and emerging challenges that are reshaping the future of justice and governance in the digital era. Today, we conclude this anniversary celebration with three highly relevant presentations addressing the ethical use of artificial intelligence in the judiciary, the evolving dimension of damages under data protection law in the context of malicious cyber operations, and the practical challenges surrounding electronic evidence. So, without further ado, let us begin our final program. So, our first speaker is Dr. Arben Murtezic, who will present ethical use of AI in the judiciary, focused on the concept of your CyJurII, Council of Governments. As judicial systems increasingly incorporate artificial intelligence tools, questions surrounding ethics, transparency, accountability, and fundamental rights become more important than ever. So, Dr. Murtezic will guide us through the key principles and recommendations developed by the European Commission for the efficiency of justice and the Council of Europe regarding the responsible use of AI within judicial system. Dr. Murtezic, so please join me, and the floor is yours.
Thank you much. Thank you very much. First of all, I have to say that I'm really thrilled to be part of this network, and I think it's a really huge initiative, and I really compliment and we all owe gratefulness to Judge Yassir. Know that it's mostly his enthusiasm. I hope in future we will help him more in establishing this network. And as I just said before to the colleague Kis, I'm here on the vacation in Italy, but I really couldn't miss this opportunity to be part of something important as this. As we all know, it's the first anniversary, and for the network like this, 1 year is almost nothing. I mean, I always say like when people are impatient in general, that 1 year in judiciary doesn't mean much. 1 year, I mean, judiciary is kind of, unfortunately, always moving a bit slowly. So in 1 year, it's very, very much accomplished. That's what I want to say. So because the time is running fast. What I wanted to say, just to introduce myself, I spent most of my career within the judiciary, not as a judge, but I've been 7 or 8 years the chief disciplinary prosecutor within the High Judicial and Prosecutorial Council in the Bosnia and Herzegovina, from Sarajevo. In Bosnia and Herzegovina, maybe that's the first something that I should say. And the chief disciplinary prosecutor means something like head of internal control or chief prosecutor for the judges and prosecutors, let's say. Then after that, for 7 or 8 years again, I was the head of the Center for Judicial and Prosecutorial Education, which I guess you all are familiar with this kind of centers. Somewhere you have the academies where it's necessary to finish this as the academy to be the judge or prosecutor. In our case, it's not that kind of institution. Is the center for the mostly for the continuous education of judges and prosecutors. So yes, I did that in practice. The ethical part of the judiciary I did in practice, and also in my academic work. Also, as kind of side project and something that interested me for more than 15 years, since I did my master's in UK. it was the cyber crime and the cyber security. So for decades, for almost decades, these two interests of mine have actually raised many eyebrows, because it's so different. But the time has come. But the time has come that is actually there is. These two of my interests are really crossing and touching and tanging each other. So that's why today I can speak about these subjects. What I'm doing quite often lately, because of these subjects, like that are actually interconnected. So yes, to continue straight to my speech, and I really like this kind of format, that we are not Biden with the presentation, that is more speech. I would like to say that today I will focus mostly on two documents. This is, as you said in your introduction. First of all, the European Ethical Charter on the use of artificial intelligence in judicial systems, which is product of something that we mostly in Europe call CEPEJ. CEPEJ. It is mostly coming from the French acronym. So yes, as you pronounce it, it's in English when you pronounce this acronym, it's like that, but it's very well known as CEPEJ. So what this CEPEJ does, and it's very important body within the Council of Europe. It's kind of maybe the most influential, I would say, uh, judicial think tank. It's producing different guidelines, opinions, and of course, these documents are part of the soft law. They are not binding, but have they're very highly estimated among the judiciary, especially in Europe. And why actually I have forgotten to say in the beginning. It's very interesting, and you are all aware that the Council of Europe somehow, it was kind of unusual suspect, that Council of Europe is somehow actually the world when it comes to the digital sphere, to the cybercrime, etc. We are all aware and the good that Kis is here. We are all aware of the Budapest Convention, that is actually product of the Council of Europe, but it's actually global document that reached almost every part of the world, one way or another, and somehow, as I said, there is not enough time to go deep in that, but we all know that now the Council of Europe is kind of leading this sphere when it comes to the legislation, which is sometimes binding, sometimes soft. Of course, we will give a chance to this quite new UN convention, but I guess the Budapest Convention will stay legal standard. So to come back to this first document that I want to mention is that that it's and now pay attention. It's issued in 2000. When the first time I saw it, it was maybe actually when it was issued. I was thinking like, don't we have really anything more pressing problems to deal with? Because it was 2018. Like who now deals? I had a vague idea about what artificial intelligence is there. Is and how come that it will affect us so strongly that we really have to do that? That we really have to do to issue the ethical charter on use. And now, yes, this charter, and that's why I'm starting actually with this document, which is more specific than the other, which is the Council of Europe Framework Convention, which is more general. Now here I'm breaking the academic rule to go from general to specific. And why is that? Because this is much older document, and I'm starting with that. So, as we all know, the Council of Europe actually has this triangle of pillars. It's rule of law, is human rights, is democracy. So, and these documents are actually reflecting this what is more important to the Council of Europe. The European Ethical Charter actually has 5 core principles, and some critics might say that when you hear that, and it all can sound quite general, and there are some practical solutions there, but it's more or less general, and it's like, all if you read all ethical charters, the main characteristics of anything which is called like ethical charter is that it's more general. It's kind of lying foundations than solving some everyday problems, but it's something that you can build on. So the 5 core principles are the respect for fundamental rights. So what does it mean? That all tools must be built and used in full alignment with the human rights. And of course, it's unavoidable everywhere, all around in the Council of Europe, and not in EU, but altogether in 46, 47 countries that are members of the Council of Europe. We are always coming back to the European Convention of Human Rights. So it's strongly relying on the European Convention of Human Rights, and especially rights for fair trial and right to privacy. When I say right to fair trial, it's like one discussion, and now with increased use of the AI, you can see some commenters that say like that the access to court, which is part of the right to fair trial, actually means access to judge, so that you cannot avoid the direct access to judge with any of the possible digitalizations of the courts or special use of the AI. Then, of course, after the respect of fundamental rights, the second pillar is non-discrimination, which means, of course, that you don't want the algorithms to increase bias or to persist on the already existing bias, or to cause some kind of bias because of the algorithms. We all have heard some cases that happened, for example, in the United States, with this compass system that actually predicted some behavior very much based on the color of the person. So that's something that is already in 2018 predicted, and it's already said like you don't want algorithms to run you to serve on that already existing bias or to cause it. Then it's the quality and security. Now I'm always, as I said, like admiring people who already in the 2018 had these ideas about the possible hallucinations and possible problems that the AI systems can use. Then it's the transparency, impartiality, and fairness. That's the biggest. That's the fourth pillar. And this transparency, impartiality, and fairness, of course, means that in the judiciary you have to have some reasoning why is some decision made, and with the AI, it's really that's a problem. That's one of the problem already in that then identified, and then in the years after, we thought about it, how to make AI explain us why some not decision exactly, but recommendation, and how some conclusion was made. And that's, of course, this well-known black box problem is often mentioned. And fifth, and for me, I guess maybe the most important part is the fifth pillar is that AI should be used under the user control. so that the final decision, the absolute autonomy of the judges and final decisions should always be in the hands of judges and other legal professionals using it. Of course, that sounds like self-explaining, quite easy to understand, and that sounds like something that everyone should know. But if you think more about it, it's not always so easy. There is this well-known phenomenon that the algorithms can bring you in some kind of bubble, that you can follow it quite blindly, that even if you just check some of your opinions with the AI, have some general drafts, it's very hard to predict how much actually it will influence your decision and your future work. So it's very interesting phenomenon, and much harder to establish, to accomplish than it sounds. Now, as I said, it is charter, and it's just the foundation, and the CyJurII actually established the special body that is actually constantly issuing the different opinions, and establishing the actually assessing the use of AI, the use of AI in the Council of Europe. And they have this what they call the AI resource service, and this CyberJust program that actually is following this situation in this field. Finally, to say about how this was advanced document, I can say that it already had this risk-based approach that you can find in the so many times mentioned EU AI Act, and that's actually having this kind of approach that says, like, okay, there are some uses of the AI that cause some kind of low minimal risk. It means use of AI in different CMS, in different case management systems, in some anonymizing documents, translations, clerical stuff. Then the high risk is the used to research and interpret facts, predict recidivism, or assist judge in applying the law to a case, which is something that we just mentioned. That's of course high risk, and the critical and maximum risk is the possible cognitive manipulation, using of the facial images, and of course the fully automated judicial decisions with no humans involved. So that's something that is absolutely that recommendation is to avoid this use maximally in that regard. We all know about the problems that facial recognition systems cause in practice. They're so useful, of course, but have to be used with such a huge to be used very carefully, and to be always aware that the mistakes that actually happened can cost individuals and society as such very badly. So, as I said, like, I'm not following this system. I told you about this specific document which is focused on the judiciary. But now I will have these few more minutes to mention the convention, the Council of Europe Framework Convention on Artificial Intelligence. So it's quite new, actually. It didn't enter the force yet, Just recently, it was actually signed by the EU, and it's as I said at the introduction, like a Budapest Convention, it has similar path, talking about that is more global document than the Council of Europe document in its drafting already. Some many countries outside of the Council of Europe, outside of the Europe, were involved, including the United States. And it's not, as I said, it's quite new. It's not, it didn't enter the force yet. It has to have like I think five ratifications, but that's something that is expected during this year. As I said, it's very much discussed documents, and usually it is compared with this EU AI Act, but of course it's not something that there are so many differences there, some similarities, yes, but so many differences because, as we said, the EU AI Act is kind of treating AI somehow, as some scholars say, somehow as a product. Is it safe enough to be sold and used on the EU soil, or it is under which condition is safe? So it's kind of comparable with use of some other different programs. When it comes to the Council of Europe, as I said, the human rights is actually the human. The human is in the center of the Council of Europe document, and of course it's always seen the human rights, democracy, and the rule of law. Some critics say that the wording of this convention is quite general. That it's not again that it's not affecting, that they avoided actually to affect the private persons, private companies, because it's again very comparable with the European Convention of Human Rights, that actually gives all the obligations on the states. It's reflecting, it's not targeting the private companies and private persons, but actually it establishes some obligations that directed to states. On the other hand, this kind of broad and general language that is used there is said that it's explained that actually they didn't want to firstly to put too much weight on the developing of the AI. Secondly, that the language has to be general, because we don't know in the future what this development of AI will bring to us, and so just to leave some of the principles open. Generally, it is there are again some red lines that are used in these documents, very similar as to the CEPES document we mentioned before, and you can see in the EU AI Act that the autonomy of the humans, of the decisions, cannot be damaged. That the use of AI has always to be under the human control. Of course, as we could understand, that the systems, that the using of AI cannot jeopardize the protection of the personal data, and that what is again kind of criticized by the scholars, that is kind of general, that the future use AI should always be agreed, discussed within different bodies. It's kind of very soft approach comparing, for example, with the European with the European Court of Human Rights, which is very strong when it came to establishing the protecting the human rights. So this convention actually doesn't provide us with such a strong body that would actually implement this convention. Another discussion was that maybe the starting point of the Council of Europe when it comes to the algorithms, to the artificial intelligence, was that it starts from the understanding that that algorithms are as such neutral, that there is no problem of putting some trust in them, because there is no bias. There is no bias that is actually embodied within the algorithms, which by some critics is not seen as truth. So it is said that because of the intention of the Council of Europe to have this treaty at any cost, having that global, it make this language so kind of vague, and it kind of avoided too much burden of all the parties that will sign it. So that's one of the reasons why it's very general, and it's very doubtful how much actually in practice if not further developed through the practice, it can contribute in future. However, I've spent maybe too much time on the critics, which is maybe not so much deserved. It's very important that when we talk about AI, that we finally have one document which has this pure human rights approach, because it's kind of different, and it's kind of breath of fresh air comparing with all these talking about AI as such as a product, talking from the economy aspect, from the marketing aspect. And to conclude, in mind both of these documents, use of AI in judiciary is very challenging, especially for the countries where the backlog of the cases is pressing. So there's kind of temptation to rely on AI much more than we should, and of course it's inevitable that the AI will be used more and more, but the careful approach, especially when it comes to the decision making, is strongly recommended, while in the case management we can maybe rely much more on the AI. So I guess this is right on time.
Okay, thank you very much, Dr. Murtezic, for your insightful presentation and for highlighting the importance of ensuring that technological innovation in justice remains firmly grounded in ethical principles and human rights. So if anyone has a question, please raise your hand. No? Okay, I have one then. So you mentioned that each AI tool has a specific purpose in the judicial system. So only focusing on assisted decision-making AI tools for the ones that are used to, let's say, help judges or judicial authorities in taking decisions. So how do you think that you can reconcile the need of help the judicial system to be less crowded with the use of technology, but respecting the right to a fair trial, in this case, established by the European Convention on Human Rights? So what are your thoughts about that reconciliation? How should countries think about that specific use?
Very, very good. Well, now you brought me on something that I should say maybe at the beginning of my presentation. You know, in these discussions, in the general discussions about the digitalization of the world and then the cybersecurity, etc., there are these two different approaches. Two different approaches. Some say that digitalization actually has changed the paradigm completely, changed the almost everything that when we are talking about. The others say, no, it's like this famous theorist who said, like, it's just the old wine in the new bottles. This dilemma you had different dilemmas you had even before. For example, in cybercrime, before you had people who robbed the banks on the horses. When the horses were used, then they used the cars. Then finally they're using computers. Similarly, when you think from the ethical point of view, with these strong backlogs, there are already so many temptations to make some shortcuts to the procedures and not to follow completely not to follow all the steps which are sometimes time consuming, causing backlog, but having more putting more security on that necessary human rights will be protected. So that's kind of dilemma that we already had for a long time in judiciary that had this problem. With AI, we have additional problem, and we have to put some different lenses that you mentioned, and that's a very, very difficult question. What I again would say, that we are again coming back on that what was said, that the human control, that the education of judges, the conscience of judges and all other, of course, legal professionals should be that when they use AI, they are not using human intelligence. They are using something that is not unhuman. That's one of the definitions of the AI is non-human intelligence. So I guess this ethical conscience and the general knowledge that should be always there, that using of AI is just something that's kind of tool, not something that is guiding you. And plus, of course, there are some technical issues like making more standardized, making more specialized AI systems, making it relying only on reliable sources, etc. So that's not something else. But the first step, I would say, like this knowledge and consciousness of the people using it, especially legal professionals.
Okay, thank you very much. If there is no other question, we will now move on to the second session. So thank you very much, Dr. Murtezic. And now it's my pleasure to introduce Dr. Bence Klemen, who will present on material and non-material damages based on GDPR, malicious cyber operation. So as cyber incidents and malicious digital activities continue to increase in frequency and sophistication, understanding the legal implications of damages under the GDPR has become increasingly significant. So Dr. Klemen will examine both material and non-material damages or harms arising from malicious cyber operations and evolving legal approaches to compensation and accountability, I believe. So please join to the conversation and welcome Dr. Bence Klemen. So the floor is yours.
Hello, everyone. First of all, thank you very much for having me. Could you please confirm if you see my slides? Yeah, I see that you're nodding. Thank you very much. Okay, now let's begin. So what I would like to talk about today is the damages claim system of the GDPR itself And the main example that I'm going to use and connect this topic to CyJurII is basically malicious cyber operations. Meaning that what I want to focus on today is basically what are the types of exemption possibilities for companies, organizations, whatever we are talking about, controllers in a much broader sense, if they are affected by a malicious cyber operation, and as a result of that, personal data of data subjects will be leaked out to the public. So basically, that's the thing that I want to focus on today. So the table of content looks like this. First, I would like to talk a little bit about the legal basis of this specific material or non-material damage claim under the GDPR. The specific article that we are going to tackle is Article 82 of this regulation. Then I will focus some of the applicable law questions regarding the possibilities of using separate legal norms and separate legal systems, to be more precise, to cover these kinds of personality right infringements, because not only the GDPR offers a possible venue for material and non-material damages, but also national law, and of course I will use the example of Hungary, offers a specific avenue of getting some form of compensation for the damages suffered. Then, as a next point, I will go to the practice of the Court of Justice of the European Union. I will highlight several cases, one of which will be specifically dealing with malicious cyber operations. And of course, based on that, I will offer my conclusions regarding this specific topic. If you're interested more and you want to learn more about this topic, Yasin and I are preparing an insight as a first step on this topic, comparing and contrasting Hungarian and Egyptian national law and case law on this specific topic. And we are going to publish an insight after this symposium. So let's be posted, and let's focus on this issue furthermore. So let's begin with the legal basis under the GDPR. So basically, the GDPR Article 82 says any person who has suffered material or non-material damage as a result of an infringement of the GDPR must have a right to receive compensation from either the controller or the processor for specifically the damage that is suffered. Now, primarily, this responsibility or this liability is at the controller level. However, according to the GDPR, we have a joint and several liability when it comes to processors and controllers. However, we have a specific distinction. When it comes to controllers, basically any situation arises, save for exemptions, the controller will be responsible and liable. On the other hand, the processor will only be responsible for compensation if the processor either specifically violated those instructions that it received from the controller regarding the processing activities, or they have not fulfilled their legal obligations stemming directly from the GDPR. So there is a twofold or two-pronged characterization of this specific joint and several liability, but still both processors and controllers should be aware of this possibility of being liable for compensation for damages. There is a possibility to have exemption, and this will have a very interesting and profound importance for malicious cyber operations also, because if the controller or processor can prove that they are not in any way responsible for the event giving rise to the damage, then they can exempt themselves from the damages under Article 82 of the GDPR. So this is a very clear possibility for exemption. Therefore, we should keep this in mind, and I will connect back to this once we have tackled the case law on the specific issue. Now, Moving on regarding national norms and EU law. Basically, what I want to focus on, and my bottom line regarding this specific issue is that we don't have a GDPR regulated procedural code or procedural regulation to specifically address the issue of how. Meaning that if I want to rely on the GDPR and claim compensation for the damages that I have suffered, whether it is material or non-material, I need to follow my own national rules, making it available for, claiming compensation based on the GDPR. However, these norms can be drastically different based on this distinction, meaning that if I want to claim damages based on the GDPR, the procedure will be drastically different than if I want to do the same for personality right infringements under, say, the Hungarian Civil Code or any special rule under the Hungarian legal system, for example, the Act on Freedom of Information and Protection of Personal Data. These each are separate procedures that are not the same in the national ecosystem and national legal system. This had been reinforced by a very recent decision of the Curia, which acts as the Supreme Court of Hungary, meaning that there are uncertainties regarding the specific procedural rules that apply to GDPR-based damage compensation claims. And this is not an ideal situation, as there are some situations which I also experience in my practice. For instance, in cases when a GDPR violation occurs on the state level or the municipality level, the Hungarian procedural rules make it almost impossible to launch a claim based on the GDPR. Rather, I need to reverse and try to base my claim on Hungarian national law. And this is simply because the national procedural rules for these types of procedures are not the same, and they are not making equivalent access to justice based on the claim itself and the legal basis of said claim itself. Now, let me point out some clear differences between the Hungarian and the EU models for getting compensation for personal data protection breaches, or in other words, if my personal data protection rights had been infringed, I have the possibility to ask for restitution under Hungarian law as regulated by the Hungarian Civil Code, or I can, for instance, ask for non-material damages based on the GDPR. Of course, there is a possibility to ask for simply material damage compensation under the Hungarian Civil Code, and there is also a material damage component of the GDPR. But the thing that I want to focus on are non-material damages. So the two things are drastically different. When it comes to the Hungarian restitution system, apart from the fact of the infringement taking place, no other harm has to be verified for entitlement to restitution, meaning that I don't actually need to show that I have suffered damages as a result of the violation of my personality rights. Simply the violation is entitlement enough or a legal basis enough for compensation to be received. On the other hand, when it comes to the GDPR, damages must always be proven, and this is a very clear distinction. Exemption is also based on two different concepts. When it comes to Hungarian law, exemption must be based on fault. In contrast, when it comes to the non-material damage component of the GDPR, the thing that I have already mentioned, so not in any way responsible for the event giving rise to the damage, must be proven by the controller or the processor. Therefore, while getting compensation as a legal basis is easier for the Hungarian part of claiming compensation for personality right infringements, the exemption is much easier to prove. On the other hand, it is way harder to prove damages under the GDPR. However, exemption is virtually impossible under this specific framework. There are also other differences between the two systems. For example, the Hungarian system creates a system which is based on material restitution and punishment, meaning that you can get compensation not only for the actual damages that you have suffered, but also basically the court can say, I am raising what the controller or processor should pay because I want to punish them for the infringement that took place. On the other hand, when it comes to the GDPR, it is purely compensatory in nature, meaning that you will only get the damages that you have suffered. And under the Hungarian system, courts may assess whether the application of sanctions independent of fault is sufficient to remedy the infringement suffered by the person. In case of the GDPR, this is not dependent on the degree of the damages or its bagatelle nature, meaning that under the GDPR, you will almost always get some money if you can prove damages, and there is no exemption. However, the CJurII has already experimented with the thought that a simple apology might suffice. However, under the Hungarian system, if you have not suffered a serious enough damage, then basically an apology is the only thing that you will get. Therefore, getting money out of this whole legal dispute is way harder based on the Hungarian system. And since people are pushed towards the Hungarian system from the GDPR based on these procedural rules, it is really pushing people outside of the possibility of getting money from GDPR infringements. Now, let me give you one specific case that I want to mention, and this is connected, of course, to a malicious cyber operation. By the way, this is a Court of Justice case in this situation. So, all in all, the case reflects on one cyber incident, meaning that one authority in Bulgaria received a hacking operation from unknown individuals, and these unknown hackers basically went into the database of one Bulgarian authority, and they leaked personal data from that specific database in the internet. And these included financial data as well. And of course, based on this, a number of data subjects have started to press legal claims against the Bulgarian authority, meaning that they did not care enough or did not provide a sufficient level of security that resulted in the possibility of this data breach by these hackers, meaning that they should be entitled for some kind of compensation, and the controller is therefore liable for such infringements. Now, what the court actually said in this specific situation is very interesting. First thing first, the Court of Justice has identified that the controller in question bears the burden of proving that the security measures implemented by it are appropriate, meaning that the controller will always have to show that in a specific situation, it has in fact implemented data protection and data security and information security measures and that these measures are up to the task, meaning that they should, in theory, defend the data subjects from unlawful intervention outside of the organization. Now, the exemption of the liability system based on this, and of course based on the GDPR, works like follows according to the court. The damage cannot be attributed to the controller, where we have cyber criminals on one hand acting as third parties, and they gain access to personal data in the system of the controller, and this infringement therefore cannot be attributed to the controller. They have no control whatsoever of what is happening with these cyber criminals, but exemption cannot be granted from the liability if this cyber criminal intrusion is a result of the breach of the obligation on the side of the controller. Meaning, if the data controller did not create a sufficient level of data security measures, and that is the direct reason why cyber criminals accessed, or they had the opportunity to access these systems and leak personal data or access personal data, then of course this attribution or lack of attribution will not be enough to get exempted from liability. And that is also crucial, if there were some security measures, but there is no causal link between the breach of the data protection obligation and the damage suffered as a result of the cyber criminal activity, then of course there is also a possibility for exemption. Meaning that if the controller created a system that is matching the standards of the data security measures of the given time, meaning that it was not possible, nor it would have been financially feasible to create a more sophisticated and a more enhanced regime on the side of the controller, and still the cyber criminals can access it, well, then the data controller should be exempted from liability. And that is a very clear distinction, and I will come back to this issue regarding the conclusions. Now, still regarding this decision, the Court of Justice has created the list of conditions for compensation under the GDPR. These are threefold. As usual, we need to have damage, a violation of the GDPR, and a causal link between the two. As I've already explained, there is no severity threshold, meaning that if the violation of the GDPR and the access to personal data is very tiny and it is really bagatelle in nature, that is no reason for not getting a compensation. Claiming this, and based on this, the Court of Justice determined that even fear that someone's personal data will be misused by third parties, or specifically the mere loss of control over personal data, can create non-material damage. So simply fear that my data will be misused by third parties because they were leaked on the internet, that can create non-material damage. I need to prove that, so fear must be substantiated, but still, this is a very, very important step towards creating a system which actually grants you compensation. Data subjects, in this sense, must prove that a person concerned by the infringement of the GDPR had negative consequences for him, and that these negative consequences constitute a non-material damage. Therefore, we need to elaborate on the fear that we have a misuse case of personal data in this situation. This fear must be well-founded, in case we can prove that specific circumstances at issue with regard to data subjects are in place regarding the situation and regarding specifically the fear itself. Now, this concludes this specific malicious cyber operation part of the existing case law, but I still wanted to mention in passing some of the other cases that can be found in the repertoire of the Court of Justice. For example, there was one other case in which the Court of Justice basically said that the scope of the compensation can also be an apology if that is sufficient for the non-material damage that was basically determined as the result of the procedure. And the court said that the attitude and the motivation of the controller cannot be taken into account in order to award a lesser compensation for the specific data subject. Furthermore, we have a different case which basically tells us that the mere loss of control over personal data, even if it is only for a limited time, for example, because it was made available online to the public and then later taken down, may create simply non-material damage, and basically, however minimal it is a basis for compensation. And this is very important if we think about the whole concept of this material and non-material damage compensation system. Last but not least, I would like to turn to a classic case of misposting. There was a German national who asked a tax consultancy firm to do their taxes and tax returns. However, during this process, they have informed the company that their address has been changed. The firm has acknowledged this and recorded the new address. Still, when they did these tax returns, then they sent it to the previous address. And on the previous address, this envelope were opened by mistake and later transferred to other third persons. Of course, our data subjects, who can be seen in the left-hand side, bottom left-hand side corner, were really fearful what happens to their personal data. Their tax ID was in their disability status, religious community status, and of course, a lot of money in tax returns. So actually, that really mattered who can access these kind of information. And of course, they launched a claim in a German court against this tax consultancy firm because of the non-material damage received. In this specific case, the Court of Justice once again underlined that the infringement of the GDPR not of itself sufficient to give rise to a specific compensation. But if we have that, have that damage, then we don't need to have a degree of seriousness. And once again, it was reiterated that the concept of damages includes the fear that someone's personal data might be used, disclosed to third parties, even if it was not possible as a factual situation that someone clearly accessed it. Clearly accessed this personal data, whether the envelope was actually opened, someone had seen it, someone had done something regarding it. So the Court of Justice, in my opinion, basically wants to open up the possibility to have a very wide scenario for getting compensation based on the GDPR. Finally, arriving to my conclusions. So basically, when someone violates the GDPR, there might be two types of consequences. Either someone gets an administrative fine by a watchdog authority, or you can be liable for material or non-material damage claims. When it comes to non-material damage claims, saying that the violation of the GDPR took place is not enough. The injured party, specifically the data subject, needs to show that actual damages had been suffered. These damages might include simple fear of misuse of personal data by unknown individuals, and this can also be a form, for example, of malicious cyber operations in which hackers as third parties accessed personal data and they have done something with my personal data. They might have leaked it, they might have sold it, they might have done something about it. And that doesn't really matter what that something was. If there is a clear and substantiated fear that my personal data is out of my own hands, that is a clear basis for claiming compensation. However, these malicious cyber operations can be a ground for exemption, but only if the controller shows that there were adequate security measures both on the data protection and information security level. If they were inadequate, such exemption is not possible. So we need to really show that what we've done as controllers or processors match the requirements of the day. And finally, compensation in case it was a really small, tiny violation and small, tiny damages, then only an apology can be sufficient. So an apology can be sufficient instead of getting money. But principles of administrative fine determination will not apply to how much money you will actually get. With that, I would like to thank you very much for your attention. If you want to follow me on LinkedIn, please do so. You can do it with this QR code on the slide. And once again, I would like to thank you for this possibility. And of course, I'm open to any questions that you might have regarding what I have talked about. Thank you.
Thank you, Dr. Klemen, for your excellent contributions to and providing valuable insights into one of the most challenging and rapidly developing areas in data protection law, first of all. And second, does anyone have a question for Dr. Klemen? Okay, so I have one. So would you mind going back in your slides to the part in which the court set up the topics that are needed to be proven to adjudicate damage? So if you go back, I will tell you which slide. Please go back. No, go back. Back, please. And there. So in the first a title regarding conditions of compensation, so the court established damage violation of the GDPR and a causal link. What I didn't find there that I think is important maybe to address according to your research would be first of all, do you know how the court is assessing the duty of care that the controllers have on subject's personal data, in order to define okay, this is the threshold that we should verify in which there are a sufficient measures or conditions for protecting personal data, if you can enlighten us with that.
Thank you. Of course. So this has two parts basically. One is an expert question. The second one is a legal question. The expert question is very easy. So we have to see what kind of security measures were in place on a technical level. That needs to be assessed by an expert, and the expert will tell the court if it was sufficient enough in the requirement of the time when these security measures were in place. This area develops daily, basically, meaning that security measures must be assessed at the specific point in time when the breach is taking place. So number one. And the second one, of course, will be a legal question, meaning that the court will actually analyze the whole data protection system of the controller or processor, meaning that they will see whether there was a system of data protection. For example, a privacy by design approach was followed regarding the procedures that were established in the organization. And if they find that there was something amiss, then they will find that, yes, there was actually a failure in the duty of care, as you have framed it, for the part of the controller or processor.
Okay, and I have one last question, and this is regarding the procedure. Like, would you think that it would be advisable that under or like the GDPR have an amendment in which they establish whether a judicial or an administrative standard procedure for like the whole Europe regarding compensation?
Definitely. So I think we need something that is more unified than the approach that we have today, simply because of the reasons that I have mentioned. So we have a very, very divergent process types, at least in Hungary. And the system itself was created in order to deter persons seeking justice to get their day in court, basically. And getting a unified approach would certainly resolve at least some of the tensions that are inherent in our system.
Okay, thank you very much. So if anyone has another question, please raise your hand. No, any other question? Perfect.
Very sorry, I will have to log out, but thank you very much for the possibility.
Please.
If you want to connect with me, you will reach me in WhatsApp. So
okay.
please send me a message and we can talk more about
Dr. Klemen, before you go, like, would you mind like sharing your presentation with Justice Yassin so he can like share it with us, please?
Yeah, sure. I will send an email to him in a PDF format, and you can further distribute it however you like. Okay.
Okay, thank you very much.
Okay. Ciao. Thank you. Bye-bye.
So, ladies and gentlemen, our last panelist had a problem and she could not connect today. So we are going to owe you that presentation. And then as we reach the final conclusion of this first anniversary celebration